Today's moderator is Lisa McGuire, CEO of the Manufacturing Safety Alliance of BC. Welcome, Lisa.
Thank you, Shirley, and welcome everyone. Today, I am joining you from the Fraser Valley office at the Manufacturing Safety Alliance of BC, located in Chilliwack and situated on the traditional and unceded territories of the Stolo Coast Salish people. We are grateful for the opportunity to speak to you from these shared lands this morning. A little bit about who we are. The Manufacturing Safety Alliance is a not-for-profit health and safety association for manufacturers and food processors here in BC. We're committed to helping organizations transform their health and safety culture through effective health and safety management systems, training, and certification. We have a dedicated team to support you to OC certification, and you can call on us for health and safety training, information, advice, and resources. Reach out to us if you'd like to learn more. Thank you for all joining us today for our last webinar of 2022. As we reflect on the past year, the beginning much different than the end, with policy shifting and changing at various steps along the way, causing each of us to adapt to the ever-shifting environment. At the Alliance, we're dedicated to supporting the continuous improvement of health and safety programs to prevent injuries and help keep workers within our manufacturing sector healthy and safe. It is these qualities that build strong, sustainable businesses and communities. Today, we're here to learn about the impact of the new amendments to Bill 41 and what these changes mean for workers and businesses, and how we'll need to adapt to successfully comply with the new standards. Joining us are two legal experts from KSW Lawyers in Abbotsford and the Fraser Valley region. With us for the second time, Chris is an experienced employment and labor lawyer serving the Lower Mainland and Fraser Valley. He is a partner at KSW Lawyer and the head of their employment and labor group. His expertise covers all facets of the workplace, such as wrongful dismissal, employment contracts, workplace policies, and WorkSafe BC matters, including occupational health and safety. Joining Chris is Ali, an associate with KSW Lawyers Employment and Labor Group. Also, she practices employment law, handling human rights claims, wrongful dismissals, unpaid wages, and everything in between. She supports injured workers and employers with WorkSafe BC claims. Before we hear from our expert panel, I'd like to remind you that you can ask questions using the Q&A icon at any time during the session. We will take a few questions after the first presenter, but hold most of them until the end. I now have the pleasure of turning the session over to Chris. Welcome.
Thank you, Lisa. It's an absolute pleasure to be here and join the Manufacturing Safety Alliance again. I was here a number of months ago to speak about COVID and mandatory vaccines, and so it's a pleasure to be here and be sharing with your members. I'm going to start out with an introduction, and Ali has the slides up there, so great. The piece of legislation we're talking about today is the Workers' Compensation Amendment Act number 2. This bill was introduced to the legislature by the Labour Minister Harry Bains in October 31st, 2022, and it has received royal assent already and was passed into law on November 24th, 2022. So we'll be going over the details of the bill in the presentation today and why it matters to you. But I wanted to make a few preliminary comments. We at KSW participate in a number of advocacy groups, including the Employers Forum. And so we get feedback from the forum and various other groups that represent business. And some of the feedback we had regarding this bill is that there was very, very little consultation with the business community before the bill was tabled. There was a little bit of discussion immediately prior to the bill coming into Parliament, but ultimately the changes had been structured and made, and there really wasn't much the business community could do to change anything. And so there was a lot of opposition and concerns voiced at the time the bill was introduced, just solely due to the lack of consultation, given the significant financial impacts that this bill is going to have on employers and premiums. So I'll get into that a bit more in the presentation. But this report, this bill comes following the introduction of a number of reports that have reviewed the workers' compensation system since 2018. And the two biggest reports are the Parr report, which was written by Jeff Parr, who's currently the chair of WorkSafe BC. And the second one was written by Janet Patterson in October of 2019, who's a labor lawyer. So back in July of 2020, Bill 23 was introduced, and that covered a lot of the recommendations that were made in the Parr report. So increasing the maximum wage rate for workers, more generous pension consideration for the loss of earnings pension versus the loss of function, increased healthcare entitlement, better retirement date consideration. All of these changes were to the benefit of workers. And at that time, the pandemic was still in full force. And so the government kind of actually held back in unleashing all of the changes that it had wanted to make based on these two reports, and just gave us kind of the phase one. So Bill 23 has already increased the cost of the workers' compensation system substantially. The financials of WorkSafe came out recently, and in 2021, there was a $3.15 billion in claims costs, which is the highest ever. And the premium collection from employers was 1.86 billion, which is also the highest ever. So you might ask yourself, how do we fund the system when we have a shortfall between the claims costs and the premiums? Well, WorkSafe BC has a $23 billion investment portfolio, and its investment income in 2021 was 2.44 billion. So last year, WorkSafe BC actually had a net gain of 820 million because of its investments, which actually go to subsidize the claims costs for employers. But given the way that the economy has been this year, potential recession coming, it's very concerning that we now have an introduction of amendments that are going to further increase claims costs. So all of that is, of course, very concerning to employers. And if we look back at the Patterson report, it's a 517-page report that contains 102 recommendations for making the compensation system more worker-centric and restoring the balance that some labor groups say has been upset by previous governments. So early estimates are that Bill 41 is going to increase the cost of the system by about $100 million a year. And in order to fund that, we're hearing that employer premium base rates are going to have to go up. So they've already been set for next year. There's not going to be any increase there, but for 2024, they're likely going to be seeing an increase of 3 to 5% in base rates to be able to cover the significant costs that are going to result from these changes. So that's just a bit of an introduction to the bill. I'm going to turn it over to Ali, my colleague at KSW Lawyers, who's going to start discussing some of the details of the changes. Ali, you're muted.
There we go. Good morning, everyone. Thank you for joining us today. As Chris mentioned, I am Ali, and I'm an associate here at Kane Shannon Weiler, practicing employment and WorkSafe. I will start by talking about the Fair Practices Commissioner. I think that this is going to be a very exciting change and something that is quite different from what is there right now. To give you some background, the Fair Practices Office is an independent body currently available at WorkSafe BC for employers, employees, or any party to the claim to bring a complaint to WorkSafe. And the general process is for an independent investigator to look into the efforts that have been made by WorkSafe or the employee to have their issue resolved. Sometimes claims are made when a decision is pending, so the claim doesn't proceed. And other times there's a delay, for example, on behalf of a case manager or somebody else from WorkSafe. The issue with the system right now is that each complaint is sort of looked at individually. So having a fair practices commissioner look at all of the complaints and issue an annual report for the board of directors really gives WorkSafe an opportunity to look at the systemic changes that need to be made and see what types of complaints are always landing at the fair practices office, so that they can make institutional changes rather than individualized, and hopefully make a more streamlined process for everybody. The Fair Practices Commissioner is going to be appointed by the Board of Directors, and this person is also going to issue an annual report on their findings of the complaints throughout the year. This change is going to come in effect May 1st, 2023. And another thing that's really important to note is that just like the Fair Practices Office, the commissioner is not going to be looking at the merits of the claim. WorkSafe already has an independent appeal process to do that. So this mostly will focus with procedural fairness, but that's what this commissioner is going to be in charge of doing. So I think that this is a very impactful change, because it's going to look at systemic issues rather than individualized complaints, and bring that to the upper management at WorkSafe. The other change that is coming is increasing the maximum for non-traumatic hearing loss. So like some physical disabilities at WorkSafe, non-traumatic hearing loss is capped at 15% of total disability. And this is assuming that there is no loss of earnings. So when a worker is deemed permanently disabled, they're entitled to either a loss of earnings or a loss of function. So assuming that there is no loss of function, there has been a cap on how much somebody can get for non-traumatic hearing loss. This is going to be changed to provide workers with a better reflection of the range of disability. And I'm just going to read out the policy as to how this table is going to be applied when those assessments are made. So the loss of hearing is going to be measured by calculating the average of the threshold of hearing in each ear, measured at the frequencies of 500, 1000, and 2000 hertz, in turn by pure tone air conduction, odometry, and by using an audiometer calibrated by a facility that meets the requirements established by the board. Obviously, this is going to be done by somebody who has the medical training and skills to do this, but I think it's really exciting to see that workers have the ability to get more compensation for some of these conditions that were previously capped. And this change is going to be effective this year on November 24th. The other change that is coming, I think this is going to be one of the biggest changes for procedural fairness in the workers' compensation appeal process, and that is allowing a party, WCAT, to seek out an independent medical examination. So the person is going to, this can be the employer or the worker, can apply to WCAT for an IME, and this will give WCAT, if your request is allowed, it's going to be referred to a medical expert that can provide an opinion on an issue that is pending on appeal. It's important to note that currently the employer or the worker, they're allowed to have their own medical legal opinion, but they have to seek that out themselves. And oftentimes, this applies for both the employee and the employer, it can be difficult to find a healthcare professional that is available and also willing to provide a medical legal opinion or a medical opinion on an issue that is being debated at WCAT. So having this will streamline the process and will also give either party the opportunity to rebut the other party's medical opinion that may or may not be in their favor. So they can present that medical opinion to an independent party and ask them to comment on that based on the medical evidence on file and any other medical evidence that they deem is necessary. Obviously, because you request it, doesn't mean that WCAT is going to allow an independent medical opinion to be granted. And the procedural aspect of how this will be available is still yet to be determined, including the timelines and what types of requests a worker can ask. But most oftentimes we see independent medical legal opinions when there is a representative involved. So I think that this is going to be very beneficial for parties who are self-represented, and also give the vice chair the opportunity to give people the opportunity to rebut a medical opinion on file that they wouldn't otherwise be able to do without a professional on file. I think it's also important to note that independent medical examinations and opinions can be quite complex, because you are inquiring a medical professional to comment on obviously the medical condition or a medical question, but they also have to be aware of what is the WorkSafe policy in question and what does the vice chair need to know with respect to the policy. So, asking a general practitioner sometimes to comment on the casualty of an injury or the causal relation of an injury can sometimes be more complex, and it's beneficial to give them a wholesome overview of what the policy is and how it applies to the case and the question, so that it can be more applicable to the issues under review. And if you want to request an independent medical examination, this request has to be made in writing, or however WCAT allows you to request it. Sometimes the vice chair may make an exception based on the circumstances, but the applicability of this is still to be determined. But I think this is going to be a positive step for procedural fairness for all the parties involved in a WCAT appeal. Another exciting change that is happening is that WorkSafe is going to pay compensation for retroactive payments extending over 180 days. WorkSafe currently does allow some interest payments, but it is very rarely awarded. However, an issue that is yet to be determined is how this will apply to board decisions. As you can see in the policy that I've pulled up on the slide here, section 231 notes that an interest can be paid on an amount for following a review decision of a board decision or an appeal to the Workers' Compensation Appeal Tribunal. But the board also has jurisdiction to issue retroactive payments if there is an outstanding adjudication request and it's unknown whether the board can actually issue interest payments when the retroactive payment is not at the review division or at the Workers' Compensation Appeal Tribunal. And that is yet to be determined, but we'll see how WorkSafe implements that. And the effective date of the interest payments is April 3rd, 2023. And WorkSafe has the discretion to determine what the interest amount is going to be. So we have to wait and see what that looks like. But this will give workers a better opportunity to receive compensation. That's a true reflection of the amount that they should have received. Appeals can sometimes take years, and the review division decision can take months. So having that compensation recognized retroactively puts workers in a better position to receive the money that they should have had the correct decision being made from the beginning. The other change that is coming into force is indexing benefits to the Canadian Consumer Price Index. And the cost of living allowance, or otherwise known as COLA, will go up. So to give you a little bit of background on what the cost of living allowance is a allowance made by WorkSafe to compensate workers for the realities of the market. And COLA is tagged on to payments made by WorkSafe, whether it's wage loss, some vocational rehabilitation benefits, permanent partial disability, and other temporary benefits. So the compensation that workers receive is often a little bit higher than what the decisions say because of the COLA. One of the issues that we have currently is that the cost of living calculations made by WorkSafe, by the policy that are in place right now, are not a true reflection of the current cost of living. So what's going to happen now is that the cost of living is going to better reflect the Canadian Customer Price Index, and WorkSafe also has the discretion to increase it to above 4%. And as of right now, the calculation was the Canadian Consumer Price Index -1, and they're getting rid of that. So what you'll see is that the cost of living allowance will increase, and whether WorkSafe will exercise the discretion to increase it further after if the amounts fall over 4%, that's something to be determined as well. So we'll see how that plays out. Okay, so I will pass it over to Chris, but before I do want to open the floor for any questions if there are any at the moment.
Thank you, Ali, for providing information on the effects of these new amendments on workers and employers. Just to begin, what do you think the biggest impact of these changes will be for workers?
Yeah, I think, what we are seeing with a lot of these changes coming together is that there's going to be a better reflection of having a worker's earnings restored. So as you know, the current wage rate calculations don't restore a worker's full earnings at WorkSafe, and we also have a maximum wage rate set by WorkSafe every year. So the fact that COLA is increasing, the cost of living is increasing, and that workers are being paid interest on top is going to give workers more compensation, and in turn better reflect the amounts that they are losing from not being able to return to work. That of course has impacts on employers, and Chris will touch on that when it's his turn to speak. But that's really what we're seeing with these changes, is to give workers more opportunities to have their compensations better restored and recognized, and also account for the crazy cost of living right now that is not currently being taken into consideration by the COLA policy.
Okay, thank you, Ali. And secondly, what is the impact of introducing an independent medical exam, and how does this impact the current process?
Having the opportunity to have an independent medical examination is something that workers and employers currently have, but they don't have the opportunity to get that from the workers' compensation appeal tribunal directly. So I think that's going to increase procedural fairness and also keep WCAT in par with the review division, for example, can request their own medical opinion. And WCAT doesn't often they don't have the ability to. It's supposed to be an impartial body. They can't advocate for the worker or the employer and request these things on their behalf. So having the ability to provide that to workers or employers upon request, I think can really streamline the process, and also be in a better position to answer those tricky questions when there is a difference of medical opinion. Can another party provide an opinion on that and answer those questions? So I think it's going to increase procedural fairness, streamline the process, and hopefully make vice chairs in a better position to determine issues that are requiring a medical expertise.
Thank you, Ellie. Very informative. I appreciate your perspective. Chris, over to you now to follow through with the presentation.
Okay, great. Thanks, Ellie and Lisa. And just a note for the audience, we do see there's some additional questions put into the chat, so we will get to those if we're able at the end of the presentation. So I'm going to talk about the duty to cooperate and the duty to maintain employment, which I think are two of the most significant aspects of Bill 41. And so what we have is basically the introduction of two brand new statutory obligations that apply to both employers and to some extent to workers. And in my view, they're certainly going to require employers to become much more active participants in workers' compensation claims. So I think it's important to bear in mind that these duties are triggered when a worker actually suffers a workplace injury and has the claim accepted, and as a result of that becomes disabled from earning their full wages. So these duties only arise when you have a legitimate accepted WorkSafe BC claim. And I'll talk about a little bit later that makes the claims process much more important for both parties, because the fact of the claim is what actually gives rise to these two new duties. And so it's important for everyone, I think, to understand the claims process, be able to evaluate when a legitimate claim is there, and potentially have the knowledge to appeal or protest a claim if you don't think it is legitimate, because you're now going to be facing these more burdensome duties. Another important point to note, these duties apply to both union and non-union settings. And Section 154.4 of the Act actually says if there's a conflict between the duties and the collective agreement, the WCB provisions will prevail, particularly if they're more generous to the worker. So these could even override your return to work provisions in your collective agreement if you're unionized. So be mindful of that. The other really important thing to note is these sections are not in force yet. They're going to come into force by regulation at some time in the future. We don't know when yet, but everything else that was delayed is coming into effect in April and May of next year. So my guess is, and the information I've got so far, is that these two duties will likely be coming into force in the spring of 2023. So let's start with the duty to cooperate. So Section 154.2 creates a duty on employers and workers to cooperate and work together with each other and the board to facilitate an injured worker's return to suitable work as soon as possible. And I think the rationale behind this is we want to get workers back to work as soon as we can. That's, I think, shown to be most beneficial to the worker and the employer. And so there's now this positive obligation for everyone to work together with the board to make that happen. The duty is kind of broken into three main components. The first one is kind of a communication piece. So it says there's this obligation now for the parties to contact each other as soon as practicable after the injury and to maintain communication following an injury. So this may change practices for some people, because in the past you may think, well, someone's on a compensation claim, they're kind of now the responsibility of WorkSafe. I can let the claims process run through, and if WorkSafe wants to talk to me, sure. Now you actually have to get in touch with the worker immediately. You have to start communicating with the worker about returning to work immediately, and it's no longer kind of up to the board to regulate that. It's now a positive obligation on the employer to initiate that conversation. On the flip side of that, the worker has the same duty as well. So the worker has a reciprocal duty to contact you and start being proactive about them coming back to work. And if they don't do that, the section says their benefits can be suspended or they can be reduced. So, on the flip side of it, sometimes we see workers that go on a compensation claim and they disappear. You can't reach them. You have no idea what's going on. You think they're going to be on that claim forever. They have no desire to come back to work because they're getting benefits. They can't do that anymore. They have to get in touch with you. and they could be at risk for their claim being suspended if they don't do that. The one exception to this duty to communicate is if communication would imperil or delay the worker's recovery. And what I think this section is getting at is when you have a mental health claim that might be aggravated by contact with the employer, then there's going to be an exception. How that is actually going to be sorted out is hard to say, but I think as the employer, I would err on the side of caution and communicate with the worker and leave it to the worker to say, well, you know, they shouldn't be communicating with me, or this exception applies to me. The second and third components of the employer's duty are to identify suitable work for the worker that, if possible, restores the full wages to the worker, and to provide the board with information that the board requires regarding the return to work. So again, this is more of a procedural type duty that you have to immediately start identifying suitable work that could be given to the worker once they come back to work, and you have to be proactively providing the board with that information and whatever else the board asks of you. So many of you will do that already. If a worker isn't working, you're thinking about how can we bring them back, you know, how can we offer them something that's suitable. But this is now a positive statutory obligation. And this duty, the duty to cooperate, only deals with the communication and the identifying the information. It's the second part that actually deals with bringing the employee back. So I'll get to that in a second. There's a little dispute resolution mechanism that's built into this section, and it says that if either the employer or the worker believes the other one's not cooperating with this communication process, they can lodge a complaint with the board. And the board then has to make a decision within 60 days as to whether one or the other is offside. And I'll get to the penalties in a minute, but if the employer's offside, they could be hit with a big fine. And if the worker's offside, they could have their claim suspended or reduced. So I'm a bit torn on this, because every time you introduce a complaint mechanism, you have more bureaucracy, you have more potential appeals and costs. But at the same time, it allows for some accountability. So, you know, you could have one party abusing the complaint mechanism by filing frivolous complaints and forcing the other one to defend them. But at the same time, if you've got a worker that's not being responsive, that's clearly avoiding your ability to bring them back in a good faith manner, then you as the employer could actually utilize this complaint mechanism to have the board get involved, and you know, it has some teeth because the board can suspend the worker's claim and cut off the benefits. So either side has this ability to kind of keep the other side accountable through this complaint mechanism. The second statutory duty that's introduced by the bill is this duty to maintain employment. And the first note I'll make on this is it doesn't apply to everyone. It only applies to employers who regularly employ 20 or more workers. So if you employ less than 20, generally you're going to be off the hook here. There's some subtleties around that because it says regularly employ. So, you know, if you have over 20 at the time of the injury, but you don't regularly have 20, you may be exempted. It also only applies to workers that have been employed for at least 12 continuous months before the injury occurs. So it's not applying to new workers, and it's not applying to smaller businesses under 20 or more. So the first step, I think, is to assess, you know, does this actually apply to me? And second, is this a worker where this duty is actually engaged? And I think the reason that we have the exemption on the 20 or more is this is a duty to accommodate. And the larger organizations, WorkSafe is saying, I think, that will have a better ability to accommodate and to comply with these obligations because they'll have more flexibility as far as being able to bring someone back to work or move people around. So what is the duty? Ultimately, it is, you can kind of consider it like a maternity leave for WorkSafe BC claims. So you kind of, there's a protected leave now for someone that's on a WorkSafe BC claim. In the past, if you had a worker on a claim, and they would engage with the board regarding their ability to come back to work, the board would come to the employer and say, do you have suitable work? And as the employer, you could say, no, I don't think so. We don't have anything. And then the board's going to say, okay, and they'll go on to the next phase of vocational rehab. And you wouldn't suffer any consequences for making that decision insofar as WorkSafe is concerned. Now you actually have this positive obligation to bring the worker back to your workplace, up to the point of an undue hardship for you, which I'll discuss. There's two kind of scenarios that are identified in the section. The first scenario is where the worker has gone through the WorkSafe process, they've done their treatment, healthcare, and WorkSafe has determined they're fit to work, but they can't come back to the essential duties of their pre-injury position. So let's say you've got an employee that works in the warehouse doing some heavier lifting, they suffer a permanent back injury and have chronic pain. WorkSafe says this employee can't work in the back lifting boxes anymore, but they can do lighter duty work. So in that situation, you now have a duty to offer this employee the first available light duty work that they can do. And so, whereas before you could kind of decline and say, sorry, we don't have anything, you now have this obligation to do an assessment and offer anything that might be available that fits within their restrictions. It talks about suitable work. So what is suitable? It's not defined in the legislation, so that'll probably be borne out in decisions and perhaps policies. Do you have to offer work that the worker is not trained or qualified for? I would say probably not, because that's not suitable. I mean, if they could be trained for that work, maybe there's an argument there. Do you have to create work that you don't actually have for the worker? I would say no, because it talks about the work being actually available. So I think, there are limits on it, but definitely it's more of an obligation than what you had before as far as the Workers' Compensation Act. The second situation that's contemplated is where the worker can return to work and the essential duties of their pre-injury position. So in that situation, you have to give them their job back, or you have to give them a comparable job that pays the same. So once this worker's coming back from their claim, you have to get them back into the same warehouse job, or give them a similar job that's paying the same. So the limit of this duty is described in subsection 5, and it says the employer must make any change to the work or workplace that is necessary to accommodate a worker up to the point of undue hardship. And again, undue hardship is not a defined term in the statute, but many of us are familiar with that duty because it's a concept that comes from human rights law. And this duty to accommodate up to undue hardship, it actually already exists under the Human Rights Code. So we can kind of draw from the human rights law to give a sense of how WorkSafe is going to interpret that term. And I think undue hardship it's a very high threshold, but it's not an impossible standard. So if you're looking at bringing someone back, you generally don't have to create a new position for them. You generally don't have to displace other employees. Like, you don't have to fire another employee to bring back an injured worker. Those would be considered undue hardships. But the bigger you are and the more flexible you are, the greater this duty is going to be. And you certainly, in certain situations, have to be creative in fulfilling that duty to accommodate. It may involve changing around positions. It may involve changing around schedules, the way you operate, to be able to bring someone back to work. And so it's a very complicated concept, and I think is going to introduce a more complicated process into the return to work regime for WorkSafe. Why this has been put into place when we already have a duty to accommodate. It's hard to know that. I think what we have now is two overlapping jurisdictions regarding duty to accommodate. We have the Human Rights Tribunal that can deal with complaints based on discrimination for disability. And now we have WorkSafe BC who can issue fines if the employer doesn't comply. So, that's certainly more of an issue for employers, because you could be facing two separate complaints for the same set of circumstances. There's some important limitations and timelines that apply. If a worker is off work for 2 years or more and unable to come back, then the duty to accommodate goes away. So this kind of mirrors this concept of frustration of employment, which says if you don't come back to work within 2 years or more, generally the employment contract can come to an end by frustration. So that also applies in the WorkSafe situation. If they haven't come back after 2 years, you no longer are obligated to keep their job open or find a suitable accommodated position. The other piece that's concerning, in my view, is this 6-month provision that comes in subsection 8. So if you do have a worker that comes back from a claim and you terminate them within 6 months of them coming back, you are automatically assumed to have breached this duty to accommodate provision. And the burden then shifts to you as the employer to rebut this automatic inference that the claim was the reason for the termination. So you could have many good reasons to dismiss someone after they come back, just cause, all that kind of stuff, but you're now going to have to be justifying that on a reverse onus situation to avoid paying a fine. And so you've got this kind of 6-month rule that applies where you really don't want to touch the situation unless you're really prepared to deal with a complaint. Going to the next slide. So what are the potential penalties if you don't comply with these duties? The new provision says that WorkSafe can issue you an administrative fine up to the maximum wage rate in force for the calendar year. So to give you a sense of the maximum exposures, the 2022 rate's 108,400, and then the next year's rate is going to be 112,800. So if you breach either of these two statutory duties, you could be facing very, very substantial fines. And of course, you do have a right to appeal to the review division or WCAT regarding these penalties. But again, that's an extra cost and an extra process that you have to deal with. One thing that's notable, this is dealt with as an occupational health and safety fine. It's not compensation that goes to the worker, it's money that goes into the accident fund. But notwithstanding, I think it gives the board a very powerful enforcement tool to ensure these duties are being complied with. And given the fact that the employee can initiate the process, it again creates an ability for workers to make life very difficult for employers. Going to the next slide, I'll just touch briefly on claim suppression as the last topic. Section 73 of the Act is being amended through this bill to create a formal prohibition against claim suppression. And so basically it says an employer must not do anything to dissuade a worker from making a WorkSafe BC compensation claim or receiving WCB benefits. For most employers that operate above board and within the lines, this is not going to be a problem. But I encourage everyone to read it carefully, because we're not just talking about the situation where where a worker is being threatened not to make a claim. It says any kind of inducement, any kind of persuasion to discourage a worker from making an application for compensation is prohibited. So this could be something as small as a subtle comment like, you don't need to put in a claim for that, or, just, stay home tomorrow and we'll cover your wages. Don't bother going through WorkSafe. That is now an offense under the Act, and it can be prosecuted as an offense under the provisions of the OHS section, and the penalties can be severe, including jail time. So be very, very careful with this section and ensure that everyone's appropriately trained as far as dealing with WorkSafe claims and communication with workers. Just going to the next slide here, we've done a summary of the commencement dates when all these various sections come into play. So you can see that some of the stuff is applicable now, including the claim suppression section I just mentioned, and some of those financial changes. Some of it's coming into effect in the spring of next year, April and May of 2023. And then that's also when we think these two new duty to cooperate and maintain employment are going to come into effect as well. So I'll just quickly finish with some takeaways before we get to our questions. Employers, I think, have a lot more skin in the game now when it comes to claims, because a legitimate claim will trigger these two duties. So get to know the Compensation Act, get to know when you might have a right to appeal a claim. Secondly, communication is key. So you need to be talking to the worker right away. You need to be talking to WorkSafe, cooperating with WorkSafe. And if not, you could face substantial fines. Another point is to keep good records. There are now many important timelines and deadlines that impact whether you have an obligation or not. So are you 20 or more employees? Has the worker been with you for 12 months? Has the worker been on claim for more than 2 years? Has it been 6 months since the worker came back? All of these timelines are important to put into your diarization system to understand what your obligations are, and be very mindful of that 6-month rule. When a worker comes back, if you terminate them, you're going to have to justify that and ensure that it wasn't because of their claim. And definitely keep an eye out for communications from the Safety Alliance and other resources as to when this all is going to come into effect and which policies are coming in to help interpret it all.
Thank you, Chris and Ali. It's fantastic to be able to tap into your expertise in this area. I very much appreciate your time today and a lot of information. As a launch to the Q&A, and please, as you're thinking about your questions, please continue to put them into the chat. Really got a question that prior to the webinar that I wanted to share with you as a launch. How do you think these amendments will change worker responsibilities when it comes to return to work? And Chris, I know you went into detail about this. Can you just summarize, how do you think these impacts will change worker responsibilities?
Yeah, absolutely. I think there's a lot more responsibility placed on the worker now to be proactive in engaging with the employer. There's two parts of that. There's a duty to communicate that I talked about. And then if the employer requests, the worker has a duty to help them come up with suitable alternatives for coming back. And the board kind of becomes the regulator of this process by offering the complaint resolution mechanism and requiring both parties to be cooperative with it. So I think there's much more responsibility now on the worker, which can definitely be a good thing if everybody is working towards the same goal of the worker coming back to work safely.
Okay, thank you. Another technical question aligned to that, for the duty to cooperate in regards to backdating to past claims, or only for claims from the date when the duty was implemented. So how's that transition going to look like? Any thoughts on that?
Yes. So as of now, it doesn't apply. When the sections come into effect in April of 2023, there's a transitional section in the Act which outlines the timeline for how far back the injury can be before this duty applies. So that's something that we'll put in our materials just to make sure that everyone knows, which injuries this actually applies for. I think it's between 6 months and 2 years. I don't have it on hand.
Okay, no, thank you. A lot of details, right? It's all about the details. Another question is, what happens when you offer suitable duties, but the worker would have to relocate and WorkSafe BC would find it to be unreasonable for them to relocate? Any thoughts about that scenario?
Yeah, that's a great question. And I think that goes back to the interpretation of what is suitable. Right. Are we looking at suitability just from the perspective of can they physically do the work? Or does suitability encompass a broader context, such as do they have to relocate? I think, if it's moving from one office to another one that's across the street, probably still going to be suitable. But if it's moving to, somewhere 5 hours away, that would be a different question. If it's moving from Surrey to Vancouver, that's an interesting one. So those are the kinds of decisions that the board is going to have to consider. And I think ultimately we'll see policies around these types of interpretations. But again, these are the types of disputes that are going to arise now.
Okay, yeah, no, a lot of what is reasonable, right? Questions. Another question, how does this differ from the current IHP process at WCAT?
IHP process?
Yes, that was one of the questions that was coming in.
I'm not sure what that is.
Okay, so getting clarity from that, from that individual would be very much appreciated. And then another question as it relates to the FPO administrator. Do you think it's important to make the FPO aware of the issues from now on, recognizing there'll be an FPO commissioner? What are your thoughts around that?
Yeah, I think I've had mixed reviews of the current Fair Practices Office. I think for workers, it can be generally a bit more effective, but for employers, it may not be as effective. And so having a formal independent commissioner be able to actually have the power to make recommendations and deal with systemic issues and change policies, I think is definitely going to make it more of a worthwhile process. And so I would encourage employers to make use of the new process and certainly give it a shot, because it may well be more effective than the current one.
Okay, thank you. And the IHP is independent health professional.
Okay, yeah. Ali, do you want to take that?
Sure. So if I understand the question correctly, is, what is the difference from the current system to the implementation of WCAT being able to appoint a health professional to provide an opinion?
Yeah.
Is that before, the parties were at liberty to seek this out themselves. And like I mentioned previously, getting these opinions can be very complex, and the person writing the opinion would really benefit from having a solid understanding of the applicable WorkSafe policy that surrounds the question that is being debated at WCAT. And, can people continue to seek an independent health professional? Absolutely. But the difference now is that WCAT can allow a party to seek this and help them appoint that person. And that's something that was not permitted in the WCAT rules before. And I think it's going to really assist the process when a medical issue is being debated, and perhaps, the employer doesn't know how to address some of the questions under appeal. They can ask WCAT for an independent medical assessment to comment on the issues that are being under dispute. And it's I recognize the question because it's something that was there before, but it wasn't really integrated into the WCAT appeal process, and now it is. So I hope that answered the question.
Thank you, Ali. I think that's very clear. Another question, do any of the requirements apply to the less than 20 employer size, specifically the 6 months grace period post-injury?
No,
Great.
so the duty to cooperate applies to everyone. So that's the duty to communicate, duty to come up with suitable work alternatives and share that with WorkSafe. But the duty to maintain employment and the 6 month protection only applies to the 20 or more situation.
Thank you, Chris. And looking at the hour at 5 minutes to, really appreciate your time, and we're going to have to stop here. Thank you both for sharing your insights and thoughts with us today about these changes and amendments. And I expect there'll be lots of questions on this into the future. So again, thank you for being here today and joining us and sharing with us on your questions as well. If we didn't get to your question, we'll do our best to respond to them in the follow-up. A quick reminder as we move through nominations or another topic are open and already coming in for the 2023 Safety Excellence Award. So there's 6 special health and safety awards that are awarded at our annual Pinnacle Awards Gala here in June. take a few minutes to review the award lineup and criteria, and nominate your company, your Joint Health and Safety Committee, owner or senior executive, or the safety hero on your team, and get inspired by the 2022 award winners on our website. Visit us online anytime for help or to access our full library of webinars, resources, and training. Please watch for an email tomorrow with a link to the recording of today's session, a lot of information there for you, and a survey as well to share your feedback and topic ideas. Thank you all for attending this morning. We hope you have a happy, healthy, and safe holiday season. We look forward to working with you in the new year. Until then, take care.